Honorable Speaker, a particular one case in point is the Kenyatta University report that, Honorable Speaker, we are told that a whole area has been occupied by people who just entered the compound and decided to put up high-rise buildings in an institutional compound. Honorable Speaker, it is very worrying because this has happened, and it has happened when the institution has full management, Honorable Speaker. And Honorable Speaker, when I listened to this report was being presented by the mover who is in this house, it was very clear, Honorable Speaker, that public resources are going to waste. An institution where the committee visited, and they went and they were told that a 600 million building was put. And when they asked where the building is, they were just told it was somewhere there. Honorable Speaker, if this is how public resources are being used, then, Honorable Speaker, as a country, it is very worrying. The trend is extremely worrying. And, Honorable Speaker, I want to urge this committee in particular, as they table this report before this House, Honorable Speaker, let it be very clear that after tabling the report, let us go even deeper, Honorable Speaker, to ensure that those people capable of misappropriating public resources are brought to book. Honorable Speaker, public land, it is not land that can just disappear. And we are told 300, 200 acres, and then by and by, you go and find that land is no longer public land, it belongs to private individuals. Honorable Speaker, I want to thank the committee for coming up with this very bold report that is unearthing the evils in our public institutions. Honorable Speaker, I want to support the report and say, as a country, Honorable Speaker, time has come when we should call a spade a spade. Get these reports and act, Honorable Speaker.
Of education. Through the reports that have come from the way these universities are run together with the TTIs, Madam Speaker, the best way to kill a society is just to compromise their standards of education, and that's it. You come up with half-baked doctors that in operation will leave sponge and other medical equipment inside a patient, Madam Speaker. Buildings will come tumbling down in the hands of quacks, masquerading as engineers, Madam Speaker. You will have a society that does not pay much attention to research, which is a component of education, Madam Speaker. And therefore, if these reports are anything to go by, then as a nation we must be very, very afraid. Madam Speaker, education, as has been said, times more than number, is the key to a better living. But if we compromise that very key, then the future of our generations and the generations to come will. If we are killing our universities, and the University of Nairobi, which has brought so many people into the limelight, Madam Speaker, very many people went through this most prestigious university of our country, a university that ranks so highly in Africa and internationally, but just because of poor management and the appetite for corruption, we are killing the University of Nairobi. It is a travesty, Madam Speaker, and this must be looked into. If it is about management, we still have men and women out here who are qualified to run these universities. Let us put them into these universities and bring them back to life. When we were going to school, Madam Speaker, any person who got admission in private schools, that was a failure. In fact, we used to call them harambes, to simply mean that they were belonging to people who were not government. The government institutions were the in thing. And each time we got letters from government institutions, we knew definitely that you have passed your exams. But how it turned around that private institutions do better than public institutions is a wonder, Madam Speaker. It is the government that comes up with the regulations. If we allow private institutions to fester, then who will control even the fees that are to be paid? If we kill our public universities and only allow private universities, who will afford education in these private universities? And that is why I was even very afraid that we are selling government institutions at the altar of private investors, Madam Speaker. Public universities must be the barometer upon which every standard is measured. That is why you have Kenya Bureau of Standards, not a private entity, but a public entity. Bureau Veritas in the international community. Public institutions, Madam Speaker. And therefore, if this report is adopted as is, we must reset this country and take it back to where it has been. Unfortunately, even with the advancements that we now have, with digital platforms, that our management then becomes a problem to us. You would have expected that with all these advancements, we would have better management of our institutions and our firms, Madam Speaker. But now the reverse is becoming true, that the current generation cannot run institutions. Institutions that our grandparents put a lot of their effort, sweat and blood, for them to be going concerns, Madam Speaker. And therefore, as a nation, there are many things that have gone wrong, but we have to step back, reflect, and retool anew for our country to move forward. And therefore, I support this report, Madam Speaker, and I thank you for the opportunity.
Very well. Chair, now you can make your reply.
Thank you, Madam Speaker. I beg to reply. But first, let me sincerely thank the leadership of this institution, of the National Assembly, starting from the Speaker, the Clerk, our own committee clerk, Christine Deritu, and my members, beginning with my able deputy, Anthony Kibagendi, Ambassador Francis Sigei, Honorable James Wamashuku. I want to thank them, Honorable Speaker, because since we were constituted initially and reconstituted second time, Honorable Speaker, we have never lacked quorum as a committee, which is not something we take for granted, but we want to thank our members for their commitment and their contribution. Honorable Speaker, in line with the mandate and in a bid to reduce the audit backlog, the committee resolved to first consider the report of the Auditor General for the financial years 2018-19 to 2020-21. This decision was made to ensure that past audit queries are addressed and that the institutions under our oversight are held accountable in timely manner. Madam Speaker, I'm pleased to inform the House that the committee has since commenced consideration of audit reports for the financial years 2021-22 to 2023-24, which brings us up to date. This is in line with the requirement of the Public Finance Management (PFM) Act, which demands timely scrutiny of public investments for effective financial oversight. Honorable Speaker, if this House may recall, there is a case between officers of the City County of Nairobi and the Auditor General. And the court ruled that the Auditor General must table these reports in this House upon which the House, the necessary committees, audit committees, must within 3 months have dispensed with them. I want to report to this House, Honorable Speaker, that we are now almost at par with the requirement, the constitutional requirement, and in a few months, Honorable Speaker, I think our committee will have dispensed with all the issues that we are supposed to deal with, and will be good to go. Madam Speaker, having tabled the committee's report, I now wish to urge the Committee on Implementation to move with speed to follow up on the implementation of the recommendations contained therein. This is particularly important as some of these recommendations are time-bound and having far-reaching implications on the quality and efficiency of service delivery in our public education institutions. Honorable Speaker, when I was moving our report, I mentioned that 2 committees of this House in the last Parliament, the Committee of Health and the Committee of Implementation, reached some decisions on some of these institutions, precisely the hospital, the Kenyatta University Referral and Training Hospital, that is supposed to, the students of Kenyatta University are supposed to have full access to this institution because that is the purpose for which the institution came to being. But up to now, Honorable Speaker, you realize that 5 years later, that decision has not been implemented. So we call upon the Committee of Implementation to be firm and to ensure that decisions of this House are followed to the letter. Another incident, Honorable Speaker, is the issue pitting the trustees at the KIST, Kiambu Institute of Science and Technology, and the Board of Governors. The TVETS Act of 2013, Honorable Speaker, dealt the last nail on the coffin for these so-called trustees issues, that the institution has to go back into the hands fully of the management of the school and the board. That, Honorable Speaker, the trustees have, without mandate, gone ahead and even borrowed, taken loans on the titles of these institutions. It is an immoral thing, and it is something that we need to follow up very quickly. And I'll be asking this House that upon approval, Honorable Murugara wants to inform me. I don't know if that is.
You want to be informed?
Yes, Honorable Speaker.
It's not really. It's purely because the line he's taking is actually is on the motion, while this is supposed to be a reply. A reply is a response to what the contributors have said, where you feel you need to clarify. Otherwise, the line is taken, it's like he's moving the motion again.
Honorable Speaker, Honorable Murugara was not here. These issues were raised by members. And it's on that basis that I'm clarifying that 2 committees in last parliaments reached decisions about this. And up to now, it has not been implemented. We are asking the implementation committee to be more firm, Honorable Speaker, and to ensure that the management, the running of the institution of KIST goes back to the TVET itself. That is what we are saying, Honorable Speaker. And Honorable Murugara, next time, just be attentive to some of these things. You're a senior member and I respect you. Madam Speaker, key among the committee's recommendations are the following. One is that the embargo placed on the government from initiating new projects must be followed to the latter, and that the government must ensure that it completes most of these institutions who have stalled projects complete their projects before starting any new other project. This is to avoid resource wastage and ensure value for public funds. Madam Speaker, the committee remains committed to its role and continue to work diligently to ensure accountability, transparency, and efficiency in utilization of public resources in the education sector. Most importantly, we urge the government to be dealing with disbursements of monies to the relevant institutions in time, capitation money, to ensure that vice chancellors and principals of these schools are not stressed and that students are not disrupted in their process of learning. Madam Speaker, I beg to reply. Thank you.
We shall defer the putting of the question on that motion. Next order.
Order number 16, the Political Parties Amendment number 2 Bill, Senate Bill number 26 of 2024, second reading.
Leader of Majority.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move the Political Parties Amendment Bill 2024 to be read a second time. Honorable Speaker, by way of introduction, the bill seeks to amend the Political Parties Act 2011. And the import of this amendment, Honorable Speaker, as I set off, is to replace the Office of the Registrar of Political Parties with the Independent Political Parties Commission. That is actually what it is about. Simple. So I can go into the details, but I would like Kenyans and everyone to know what this political party is about. We have been used to the Office of the Registrar of Political Parties, but we are transforming the Registrar of Political Parties office now into a commission so that it can have the independence like the Chapter 15 commissions in the Constitution, Honorable Speaker. Honorable Speaker, as a background, the National Assembly and the Senate resolved to establish the National Dialogue Committee, the NATCO, the famous NATCO committee, to facilitate dialogue and consensus building and recommend appropriate constitutional, legal, policy reforms on issues of concern to the people of Kenya. Honorable Speaker, at that particular time, when the NATCO committee sat in the bipartisan talks, the talks were narrowed down by NATCO to the following thematic areas. One of them is electoral justice and related matters, outstanding constitutional matters, fidelity to political parties or coalition parties and the law on multi-party democracy, entrenching funds into the Constitution, and establishment and entrenchment of state offices. Honorable Speaker, so this bill is born out of that NATCO discussion and the report that was tabled in this House, Honorable Speaker. Honorable Speaker, with respect to fidelity to political parties or coalition parties and the law on multi-party democracy, NATCO recommended amendments to the Political Parties Act 2012 to establish the Political Parties Regulatory Commission. And this is what this bill is about, Honorable Jared Okello. I can see you're listening attentively. Following the adoption, Honorable Speaker, of the NATCO report by both houses, the speakers and leadership offices has deliberated on the modalities of implementing the recommendations contained in the report and agreed that the Political Parties Amendment Bill, which is this one, 2024, be introduced in the Senate. It was an agreement that some bills be introduced in the National Assembly and others be introduced in the Senate. This particular bill, Honorable Speaker, was introduced in the Senate with amendments on the 5th of December 2024. The bill was referred to the National Assembly and was read our first time on 13th February 2025. Pursuant to the standing orders, the bill was committed to the Committee of Justice and Legal Affairs, chaired by the Honorable Legal Counsel Murungaru, the Honorable Member for Tigania, for Tharaka, to facilitate public participation and thereafter a report to the House to inform debate. Honorable Speaker, you know I always think Tigania and Tharaka are the same. So the contents of the bill, Honorable Speaker, I just want to delve into the contents of the bill so that we can easily understand, Honorable Speaker. The Political Parties Amendment Bill 2024 proposes a raft of amendments of the Political Parties Act 2011, which I will wish to highlight, if you allow me, Honorable Speaker. One, Clause 2 of the bill seeks to amend Section 2 of the Principal Act by deleting the definition of the word commission. You know, initially in the law, there was a definition of commission. Now we want to replace the commission, in this case, shall mean the Independent Political Parties Regulatory Commission, established under Section 33 of this bill. The clause further deletes the definition of the term registrar. You remember we used to talk about the registrar. So this bill actually deletes the term registrar in that area. Honorable Speaker, Clause 3 of the bill seeks to amend Section 21 of the Principal Act by deleting Section 7. So when we delete Section 7, what do? We substitute it with a new subsection to allow a political party dissatisfied by the decision of the Commission to appeal to the High Court. Remember, initially, you would go to the tribunal and you would appeal at the tribunal and all that. But now you can appeal at the High Court against the decision of the Commission. If the Commission makes a decision that you are not in agreement. Honorable Speaker, Clause 5 of the bill repeals the whole section 14A, which provides for the resignation from a political party. So that whole section on resignation of a political party, which is in Section 14A, is now deleted. I'm sure the Honorable Murungara will speak more on this because he will move and he will second me, and I'm actually preparing him to second me. So get ready to do that. Honorable Speaker, Clause 6 of the bill amends Section 32 of the Principal Act by deleting subsection 1 and substituting it with a new subsection. Further, Honorable Speaker, subsection 2 of the Act is substituted and replaced with further subclauses to address the issue of financial audit reports and the accompanying documents to be filed at the end of every financial year and submission to the Attorney General. This is a deliberate step towards entrenching accountability within our political parties. Honorable Speaker, political parties are funded by taxpayers' money. And if they're funded by taxpayers' money, Honorable Speaker, we demand for accountability. Just like Jack Wamboka demands accountability in universities and colleges, we also demand accountability in political parties because they receive, actually, Honorable Speaker, we fund these political parties. They receive a lot of money. This is taxpayers' money. What do they do? Because a lot of the time we don't see any party activities. So probably the chairman, the secretary general, and the people there hold a few meetings and use the money. Honorable Speaker, we are saying, if we are going to fund political parties, and if political parties must continue to receive money from the exchequer, we demand accountability from them. And this we are entrenching in the law, so that we don't just give them money. People form briefcase parties. They get 1 or 2 members in the National Assembly, 1 in the Senate, and a few in the local assembly there, like the one where Jack comes from. And they have money. Honorable Speaker, they have money. I'm moving, Honorable Speaker. I can't allow point of order. I'm moving. So, Honorable Speaker, we want those parties, even if it's a village party that has only 3 MCAs in that village, and they are given funds, we want them to account for every coin properly used. And therefore, we are introducing in this new bill, Honorable Speaker, subsections that ensure that accountability is prime in this. Honorable Speaker, Clause 7 of the bill repeals and replaces the whole Section 33 of the Principal Act. This clause provides for the establishment of the Independent Political Parties Regulatory Commission, which seeks to replace the current office of the Registrar of Political Parties. Honorable Speaker, Clause 7, Subclause 2, establishes the Commission as a body corporate with perpetual succession, capable of acquiring and disposing of property, suing and being sued, and doing or performing all such acts and things as a body corporate. Honorable Speaker, this is a common clause in all these commissions, so I don't want to belabor that, Honorable Speaker. Honorable Speaker, Clause 7, Subclause 3 highlights the functions of the Commission. The functions of the Commission are highlighted, Honorable Speaker, in Subclause 3 of 7, and asserts that in the performance of its functions, the Commission be independent, and I think I like that word, be independent and not subject to the direction or control of any person or authority. And I think that's what Kenyans have been demanding, that the political parties, the office of the Registrar of Political Parties was seen as an appendage of the executive, Honorable Speaker. and therefore might not have, because it fell under the office of the Attorney General, and therefore it didn't have much independence. But this one now, just like the Chapter 15 commissions as established in the Constitution, where it is independent and it is not subjected to any person or authority, including myself. Honorable Speaker. Honorable Speaker, Clause 7 highlights the membership of the Commission to comprise, and this is what I like about this political party, this new one, Honorable Speaker. It says this: it comprises of 5 members nominated, 2 members, man and woman. In fact, that's very interesting. 2, it has to be a man, it has to be a woman, nominated by the majority party or coalition of parties in Parliament. 2 members, man and woman, nominated by the minority party or coalition of parties in Parliament. And 1 member nominated by the Parliamentary Service Commission, being a representative of a non-parliamentary registered political party. Non-parliamentary. So the majority have their share of 2. The minority have their share of 2 because they are in Parliament. But those that are not in Parliament, Honorable Speaker, those that are not in Parliament, Honorable Speaker, also have an opportunity to nominate 1. I don't know whether we'll have the saga that we had under the IBC one, where people say, no, we want this guy, or we want this guy, and there was not agreement, and therefore delayed the whole process. But, Honorable Speaker, what I think we also missed, and which probably is debatable, and which Honorable Murugaro will shed light for us, what about independent members? What about independent members that are in Parliament? Do they have an opportunity, or we disregard them because they're independent already and they don't need any affiliation? So that is food for thought, Honorable Speaker. Honorable Speaker, Clause 7 also provides for the qualification for appointment as a member of the Commission, which includes 1 must hold a degree from a university recognized in Kenya, has proven knowledge and experience in any of the listed fields, 10 years of post-qualification experience in the relevant areas of expertise, and meets the requirement under Chapter 6 of the Constitution. Honorable Speaker, further, the clause expounded on the grounds or reasons for a person not to qualify for the appointment as a member of the Commission. Honorable Speaker. So those are 10 years post-qualification experience is very important, and a degree, Honorable Speaker. And this time I like this one because it does not tie us to the normal thing of has to be a lawyer, has to be a judge. You know, almost all this commission, there is that thing of has to be a judge, as a lawyer, as if law is the only profession that matters in this country. Honorable Speaker, I think I want to say this is a good piece of legislation, Honorable Murangara. Chapter 7 further highlights the tenure of the office to be a term of 6 years, and I think it takes the shape of independent commission. 6 years and not eligible for reappointment, and they shall serve for over full-time basis, Honorable Speaker. The clause further provides for instances where the seat at the commission can be declared vacant and the procedure for the replacement of the vacancies. Honorable Speaker, Clause 7 is heavy, so I want to continue on Clause 7. It is very, very heavy, Honorable Speaker. The bill provides for grounds for the removal from office to include serious violations of the Constitution or of this Act, gross misconduct, whether in performance of the members or office holders' functions or otherwise. Honorable Speaker, physical or mental incapacity to perform the functions of office, bankruptcy or incompetence, and others are reasons why someone will be removed from the commission. Honorable Speaker, Clause 7 again provides for the procedure of the commission to conduct its business and affairs in accordance with the 6th schedule. The terms and conditions of the service at the commission is that the salaries and allowances will be payable to, and other terms and conditions of the service for the members of the commission shall be determined by the Salaries and Remuneration Commission. Clause 7 of the bill further provides for the position of the secretary to the commission, the qualifications for appointment, the tenure of the office, and grounds or reasons for the removal of a secretary are also provided in Clause 7, Honorable Speaker. To further move the bill, Honorable Speaker, lastly, Clause 7 of the bill seeks to give the Commission powers to appoint staff as may be necessary for the proper discharge of the functions under this Act, Honorable Speaker, and that when they want to hire, the commission wants to hire, Honorable Speaker, they must do it in consultation with the Salaries and Remuneration Commission in terms of the salaries available to those that. So I want to tell those people out there looking for jobs, there are new jobs being created here, and they can apply, and the salaries will be good salaries. Clause 10 of the bill seeks to amend Section 34 of the Principal Act by deleting the words "or is deemed to have resigned from the political party, the registrar has been notified of the resignation," appearing in paragraph C. Subclause B deletes the and substitutes therefore a new section that a political party is dissatisfied by the decision of the commission may appeal to the High Court. Honorable Speaker, as I wind up, clause 15 of the bill amends the 6th schedule in the Principal Act and substitutes therefore with a new schedule in respect to the new established commission. This is a new commission, so the schedule 6 is actually substituted with a new schedule, and that schedule is available in the bill, and members can look at it so that they familiarize themselves with that. The amendment bill is part of the bills highlighted in the National Development, the NATCO report, Honorable Speaker, which plays a pivotal role towards the realization of national development agenda. In conclusion, Honorable Speaker, I urge honorable members to support this bill as it promotes fidelity to political parties. Fidelity to political parties, Honorable Speaker. Today, I'm a member, like what we're seeing now, Honorable Speaker, unfortunately, that today members are members of a certain political party, but they pay allegiance to other political parties, either new or old, and they have moved out of the parties that they swore to defend. Honorable Speaker, my party, the UDA party, the majority party, has always remained fidelity to the law. A few errant members who want to subscribe to other funny parties are free to do that. But, Honorable Speaker, the law will catch up with them. And therefore, I want to ask members of parliament to remain within their parties and subscribe to them. And they stop this idea of, going out the marriage to someone already. They need to stop that. And I want them to hear me. Please stop. If you belong to the UDA party, belong to the UDA party and subscribe to it. If you have a new suitor, resign and go and seek re-election on the new suitor that you are, instead of having one leg here, one leg there. It's a way of destroying political parties and destroying political party democracy in a country. We must guard against the destruction of political party democracy in this country. As a party, we will not poach any other member, but we will enter into coalition, which is agreed in this, and we will look for friends so that they come, we work with them. But we are not telling them to join our party, we're telling them to remain in your party, let's collaborate, let's develop Kenya, let's form, let's respect our parties and stay there, Honorable Speaker. I beg to move, Honorable Speaker, and ask the Honorable Counsel, Legal Counsel, for a member for Tharaka, the Honorable Murungara, Senior Murungara lawyer. Murugara, to second this very important bill. Thank you very much.
Honorable Owen today is confused with Tigania and Tharaka, then Murungaro and Murugara. So it is Honorable George Murugara, member for Tharaka.
Thank you. Thank you very much, Madam Speaker. Madam Speaker, allow me to second the second reading of the bill, the Political Parties Amendment Bill number 2, which comes from the Senate. It has been ably moved by the Deputy Leader of Majority, and from his moving speech, I think members have been able to learn a lot regarding what this bill is all about. And for those who may not capture what the speech was all about, we have a report of the Departmental Committee on Justice and Legal Affairs, which we tabled in this House last week, on the consideration of the bill, and especially clause by clause, giving justification of each clause and its compliance with the Constitution as required. The report is elaborate, and I would urge members to obtain copies, and especially to look at public participation under Article 118 of the Constitution, where members of the public, especially stakeholders and interest groups, came before us, made their representations, which representations were considered while this bill is actually being passed. We may not have agreed with some of the proposals that were being made, but it's important to point out that some of them we agreed with those proposals, and they require amendment of certain clauses in the bill, and we have made proposals in our report. It is a schedule of amendments that is annexed to the bill so that we are able to harmonize the proposals in the bill with what came out from the public when we were doing public participation. Therefore, again, we must emphasize the importance of public participation. This is where everybody who has an interest comes to voice that interest to the betterment of the laws that are being enacted for the benefit of the country. Therefore, we have a schedule, and that schedule is going to appear when we go to the Committee of the Whole House with those proposals and the justification, which we will be moving for this House either to adopt or reject, depending on how the House is going to take the proposals. Now, very quickly, I will go through the proposed bill so that everybody, including Kenyans, know what we are doing here late this afternoon or late towards this evening when we are trying to enact this law. First and foremost, it's important to note that we are undertaking a fundamental step, which step is actually to replace the office of the Registrar of Political Parties with a commission. And this commission is going to be known as the Independent Political Parties Regulatory Commission. It is a statutory commission, not a constitutional commission. That means its independence is derived from a statute, and therefore, if any of its acts contradict the Constitution, then those acts are likely to be declared unconstitutional because it is not a constitutional commission. It is established under the Political Parties Bill, under the Political Parties Act, which act we are now amending. The first several sections proposed or clauses of the bill are purely to align the office now to the commission, such that where the office of the Registrar of Political Parties appears, we replace that with commission. We have also defined commission so that anybody who does not know which commission we are talking about here is able to know that it is the Independent Political Parties Regulatory Commission, which we are establishing under the new Section 33, which is being introduced in the Act. Very quickly, what is this commission all about? Which is clause 7 of the bill, which seeks to amend Section 33 by repealing the entire old Section 33 and introducing a new Section 33 and the more sections that will follow to establish this commission. It is purely a commission, as I have said, independent, established by a statute, which means when it is independent, it can only be interfered with, not by anybody else, unless where it has conducted itself in a manner that is unconstitutional. And the most of these constitutional matters are declarations by the court and seldom by this House, not anybody else. Now, it has the first provision is what the powers it has under Section 33. Section 33A are functions. The power it has is usually the power of perpetual succession. That is why it can sue, it can be sued, it will acquire property, it will succeed itself from time to time. Then the functions are just the functions of the office of the Registrar of Political Parties. They are set in the new the new proposed section 33A. They run from A to N. And then we have a new section 33B on the membership of the commission, which the mover actually elaborated on, that we will have 5 members, and all of them would be nominated as proposed in the Act. But he did not move that section 33C gives qualification for appointment of members of commissioners, and this is where he had alluded to the fact that they have to be lawyers in most of these ones. Here, it is not solely law. We have provisions that one must hold a degree from a recognized university, then you must have proven knowledge and experience in the following fields. So, if you qualify as a finance person, a person who is an expert in management, political science, electoral matters, and the famous law, governance, or public administration, or you have, yes, in those 7 fields, then you qualify to become a member, and you can be nominated by the entity that is nominating, including the majority party, 2 members, and minority party, 2 members. Then the non-political parties who sit in parliament, the non-political parties actually are not the parties out there. They are parties that are here, but they do not have, they are called non-parliamentary parties. They sit here, but they do not have numbers sufficient to have themselves recognized as parliamentary parties. That is why it is always the UDA, ODM, the other parliamentary party must include, I think, Jubilee being the 3rd one. There is a debate as to whether Wiper qualifies. The rest of them, they are in the coalitions because they do not qualify to be recognized as parliamentary parties. Those are the ones PSC will represent and make a nomination on their behalf. Then all these persons must have at least 10 years post-qualification experience in the relevant field. That is, if you are an advocate, you must have practiced for, if you are a lawyer, sorry not to use the word advocate, you must have practiced for at least 10 years because all advocates are lawyers, but not all lawyers are advocates. But anyone who has a law degree qualifies for this. And then you have to meet requirements of Chapter 6 on integrity. A person who has conducted himself in a manner that offends Chapter 6 of the Constitution becomes automatically disqualified. And the disqualification has been discussed. Then we move to the new proposed Section 33D on tenure of office, which we have agreed it is 6 years, not renewable, which means once you serve, and then on your marks, you go home so that another new team comes in. On the 33E, it's when a vacancy arises, and then the removal from office, it goes all the way to the new section 33I on appointment of the secretary, who is supposed to be the chief executive officer. And by that extension, that person is the accounting officer of the commission. And removal of the secretary, the grounds upon which the secretary can be removed. And finally, we have the concluding clauses, which include Section 34C of the Principal Act, which we amend on when you are deemed to resign from a political party. Very important, because that deeming word has a problem, and we know for sure it's the courts who have kept most members of parliament here, because immediately you are seen to associate with another party, you are deemed to have left that party and you are liable to discipline. We agree there must be hygiene in political parties, there must be a level of cleanliness, but again, how many political parties can be trusted in this country? We keep on asking. We have seen it before. We continue to see it because there comes a time we think political parties overreach. However, because they have their own constitutions as societies, then they are bound by those constitutions to act when they feel there is a breach. Political parties funding, a very important element of our budget, especially when we are going to budget for this office. Huge sums of money are supposed to be paid to political parties. There are huge arrears. This year alone, I think we are paying about 1.9 billion to political parties in the proposed budget. I know the last couple of years, we have had to reduce that budget to cater for more urgent needs because we felt funding political parties may not be equivalent to even making provision for our prisons. But it is now clear-cut that political parties have to be funded, and this is where we are calling for accountability, such that if a political party was lucky enough to get an MCA, to get a member of parliament, or to get certain votes which qualify it to get some money from the public coffers, then that political party must be prepared to account for the money in the most meticulous manner, and the auditors, including the Committee of Honorable Wamboka, would have to move in and ensure, Wamboka's I think is on education, but we have the public accounts on public matters. They have to be audited so that this money is accounted for. For sure, we know that some of the parties are out there waiting for the money because they have no other source of income. And if that is the case, and if we are going to grow our political parties by making the provisions, there is no problem. But the problem is if the money is sent to political parties to meet hungry politicians who will actually swindle the money immediately, and it will have nothing to do with any political party, then that is misapplication of public resources. And this goes with what I keep on saying as a person, that which parties are we growing in the country? Because some of the parties that we started at independence today are pale shadows of themselves, including the long-time former ruling party, KANU. Today, it's a pale shadow of itself. Other parties like the Democratic Party of Kenya, on which I was elected my first term here, today cannot boast of anything apart from one MP, one senator, and now has gone to public service. It has only one senator. And there are many others that have not been able to live, Foda Sili and others. All of them are gone. So which political parties are we growing? And would they stand the test of time? Because if you look at the English position, it's that there are two parties, the Tories and the Labour Party. They have been there from the 17th century or something next to that. If you look at the Americans with their Republicans and Democrats, they have also been there since the early 18th century, and they have withstood the test of time. Will our parties withstand the test of time, or they will continue being one-man show dominated by the principals who, once they change their minds, those parties also change their minds into the new outfit that is going to form? All these are questions we will be asking as we continue to study the relevance and the implementation of the political parties fund to whether it is serving the desired purpose or it is not. With those very many remarks, I beg to second. Thank you very much, Madam Speaker.
Honorable members, I therefore propose a question that the Political Parties Amendment Bill number 2, Senate Bill number 26 of 2024, be read a second time. Honorable Catherine Omanyo, are you on this? Honorable Karoli.
Thank you very much, Madam Speaker. for giving me the opportunity to contribute to this bill. Let me begin by observing that the proposed political parties amendment number 2 bill, or number 26, is it 26 of 2024 from the Senate, can only be described as probably one of the most bills insensitive to the public interest I've ever seen on the floor of this House. This is a bill that seeks to elevate the interests of the political class above public interest, and it is a legislation that is serving short-term political interests of the two parties that are dominant at this particular time. Madam Speaker, this is a bill that we should debate objectively, candidly, and hopefully amend it substantially or reject it in toto. Why do I say so?
What is out of order, Honorable?
I rise under standing order number 35 to notify the House that we have no quorum and that we are dealing with very serious issues, that I beg that we continue.
Point taken. Sergeant at Arms, you ring the bell for 10 minutes. The next time this motion is on the floor, the catch of it is that you have to be in the house. If you're not, you will forfeit it. Order, members. 6:52 p.m. This House stands adjourned until tomorrow, Wednesday, 4th of June, 2025, at 9:30 a.m.